Bom, ça commence, je pense.
Aula para assistir em francês.
Podemos começar, né, Fernanda?
Recording in progress.
Tem uma aula para assistir em francês.
Podemos começar, né, Fernanda?
You can start, Professor Nemer. Fernanda said you can start.
Okay, that's perfect. Can start?
Yes.
Bom dia a todos, né, todos os estudantes, todos os colegas, profissionais da área do direito internacional, estudantes interessados na área do direito internacional. Bom dia, professora Mina. Bom dia, Fernanda. E bonjour, professor Pellet, que está aqui presente conosco e que vai inaugurar o nosso 17º curso de inverno em Direito Internacional. Eu gostaria, antes de mais nada, agradecer ao professor Pellet pela generosidade de estar presente conosco nessa ocasião. O professor Pellet, que marcou tanto a vida de jovens profissionais da área do direito internacional no mundo inteiro, é um grande professor. Ele estava me dizendo agora que, neste instante, tem mais de 65, 66 casos correntes no qual ele é conselho, advogado, além das inúmeras arbitragens internacionais que faz neste momento. O professor Pellet, que é também um professor emérito, né, da Universidade de Paris-Nanterre, onde eu tive a honra e o prazer de fazer o meu doutorado sobre a sua orientação. Ele é membro e antigo presidente também da Comissão de Direito Internacional das Nações Unidas. Ele é igualmente membro do Instituto de Direito Internacional e presidente de honra da Sociedade Francesa, né, pelo Direito Internacional, além de ser árbitro no ICSID e presidente do Conselho Administrativo de 2011 a 2017, e estar na lista de árbitros, né, em virtude do anexo 7º da Convenção das Nações Unidas sobre o Direito do Mar, a Convenção de Montego Bay, desde 2015. Portanto, é certamente um dos maiores nomes do direito internacional na atualidade, que nós temos o privilégio de estar juntos, né, nessa manhã de segunda-feira, diante do 17º curso de inverno de Direito Internacional.
Oi.
Eu agradeço muito, então, ao professor Pellet e solicito àqueles que estejam presentes, por favor, que desliguem o microfone. Por favor, parece que a Bárbara está com o microfone ligado.
Vocês vão ver e eu vou, né?
Eu peço que desligue o microfone, Bárbara, por favor.
Sim.
Eu gostaria também, nesse instante, de agradecer à Fundação Konrad Adenauer, tá, pelo apoio, na pessoa do Luiz, que é o seu coordenador de área. A Fundação Konrad Adenauer, todos vocês conhecem, é uma fundação alemã focada na cooperação e no desenvolvimento e em temas importantes como os direitos humanos, por exemplo, e, dentre esses, o direito internacional. Portanto, este curso não existiria se não fosse o generoso suporte e o importante apoio da Fundação Konrad Adenauer no Brasil. Então, a Fundação, todo o nosso agradecimento. Agradeço também a toda a equipe do CEDIM, né, a Fernanda, a Amina, o Gelton, o Guilherme, o Pedro, enfim, todos aqueles que colaboraram para que esse curso pudesse se dar, essa equipe maravilhosa do CEDIM, que está sempre pronta para auxiliar no desenvolvimento do direito internacional. Portanto, professor Pellet, é uma honra tê-lo. Je suis énormément honoré de vous présenter, professeur Pellet, et on attend tous votre conférence. Obrigado a todos, que teremos um bom curso. Professor Pellet, c'est à vous la parole.
Obrigado. Hello to all, or bonjour, bon après-midi pour moi, bon matin pour vous. First of all, let me convey a cordial hello to Leonardo Nemer Brant, who many years ago just arrived in Paris as a young junior professor in Belo Horizonte, and knowing very little French, I must say, and not much more international law at the time, who came to me to beg me to be his tutor for his doctoral thesis. I must say I reluctantly, you will remember that, Leo, I reluctantly accepted, so insistent he was, and I was fortunate to have him as one of my brightest doctoral students, with a remarkable thesis on res judicata in international law, who has been published in French and I think also in Portuguese, and is now absolutely fluent in French, is an excellent colleague, and he has become, I must say, and this might be the most important, a very, very close personal friend. It is not the first time that I deliver a course in Belo Horizonte. It is always a big pleasure, although I must say that I am a bit frustrated to have to give it through the internet, but maybe for next years we will have more opportunities to meet again in the real world. Well, as it happens, I gave a general course of public international law in the Hague Academy in 2018, and it has been published as a book in French 3 months ago. I have therefore decided to give you the scoop in English of one of the chapters entitled Practising International Law, Faire du droit. That chapter is followed by another chapter which is entitled Thinking Law or Thinking International Law, which I may go into partly if time permits. Before I get to the heart of the matter, a few words about the court, the General Court in The Hague as a whole. I must say that when I was asked to give this course for various reasons rather lately in my career, I found myself very embarrassed. What more could I say than what I had already been explained by eminent professors in the previous 86 general courses? And what more could I say than what I had already said myself? I have written a lot, too much, no doubt, including 2 general courses in the Belo Horizonte, in the CEDIN's course at Belo, in Belo Horizonte. So I had to find something new. An idea came to my mind. All my professional life has been divided between my duties as a professor and my activities as a practitioner of international law, as a legal consultant, as counsel and advocate before international tribunal, especially the World Court, where I think I have pleaded more than 65 cases. As a member, as Professor Brant recalled, of the International Law Commission for more than 22 years, for not more, but for 22 years, which is too long. And I have also been part of delegations to international conferences and meetings, and to a lesser extent, as also Leonardo explained, as an arbitrator in investment cases. So with this in mind, I thought that I would try to present international law not only as I know it as a professor, I am supposed to know it, but also as I live it, which would illustrate an idea which is dear to my heart and to my mind. International law is a tool. It is an instrument at the service of a society, in that case, the international society. And international is, I think, an indispensable tool for coexistence between its members. And it happens that for the moment, even if they are not the only members, main members remain sovereign states. Hence, the title of this general course, International in Light of Practice. And I have flunked this general title with a somewhat esoteric, I must admit, subtitle, The Untraceable Theory of Reality. Untraceable theory of reality. By theory of reality, I mean a doctrine that strives to account for all legal phenomena without succumbing to the sirens of pure theory, not sacrificing to the purely intellectual excitement of legal constructions without a concrete purpose. Again, the main idea of this general course is international law is a tool for peace, a tool for coexistence. That said, when I come into contact with the practice, or rather the practices in the plural of law, it seems to me that there can be no doubt. There is indeed something which must not be confused with politics or with the power relations that underline international law, which can be called law. Law because it is felt as such by its actors and by its recipients. I have been able to see this because I have been fortunate enough to do international law in a variety of capacities covering several manifestations of the practice or practices of international law. That said, even if I had made in this general course, but it is in French, so it is available on the internet, but only those of you who can read French could go through it. Even if I have made some incursions into my personal practice in the course, I have been careful not to turn it into a collection of memories of a veteran of international law, for international law. So I might be less restrained, a little less restrained today, especially when it comes to answering your questions, since I understand that the second part of the course, of the conference, will be devoted to questions and answers. All I have tried to do in the course is to show how a practitioner of international law sees international law in its broadest sense, from a somewhat, I would say, utilitarian perspective, without unduly complicating things. I hate lawyers who complicate law. I think they want to make law something esoteric which only themselves can understand. And I think this is ridiculous. Law is made for people and for states concerning international. And I think that if we want that law is helpful, is useful for preserving peace and coexistence, it must be accessible for day-to-day management and pacification of international law. Now, turning to our topic, there are many ways of practicing or doing, if you like, the law. We make it, we think about law, we manufacture law, and we apply it in various ways. In the words of Professor Laurence Boisson-Chazoun from Geneva, and I quote her, "Behind the tree of the practice, in the singular, there is a forest of practices in the plural." This highlights the ambiguity of the very notion of practice. There is a practice of jurists, which itself takes several forms, depending on whether they study the law, they help to develop it, or apply it. And there are the practices of the subjects of law, and even more broadly, of the actors of international relations. These practices being in turn intended to be reduced to practice in the singular by legal analysts and to guide as such the implementation of legal rules. They are at the origins, practices are at the origin of certain rules, customary norms, which are practice considered as law, and to a certain extent, general principles of law. And practice also play an important role in the interpretation of treaty rules and in the codification of custom. In both respects, practice has a key role to play in international law because, as Michel Virali noted, Michel Virali was one of my masters in the late 70s, or not late, in the 70s. And he noted, and I quote him, "In legal systems that are not fully codified or fully controlled in their application by judicial decisions, the role of jurists has always been first to study practice, that is, to discover and establish the facts even before interpreting them." This being the case, international law is not fully codified and is not usually applied by judicial bodies. This being the case, I will focus today only on the role that jurists can play in international law and not on the role of practice itself as such. What interests me today is the role of lawyers or jurists. As you know, lawyers are people who are practicing law as a job, while jurists are people who are trained in international. In a very general perspective, law is a tool. You know that I have an obsession with that. Law is a tool that contributes to the management of the international society. But a tool does not work on its own, even if it may have its own dynamics, like the broom of the sorcerer apprentice in Goethe's poem, or in the progress of artificial intelligence, which is interesting because the tool starts to become a thinker. But usually, to handle a tool, you need human beings. You need workers capable of using the tool without necessarily being highly specialized. Jurists are the workers of the law, but the legal tool is not their prerogative. Moreover, jurists can make law, but they do not make can do law, I would say, but they do not make the law. Just as war is too serious a matter to be entrusted to the military, according to the formula attributed to Clemenceau. Clemenceau was a French politician during the First World War. According to his formula, then war is too serious a matter to be entrusted to the military. I think that law is certainly too serious a matter to be left to the lawyers or to the jurists. Like all legal rules, the norms of international law have a political origin, even if the ways in which law is made are different within the state, where there are specialized organs for the elaboration of norms on the one hand, and on the other hand, at the international level, where the maker of norms is diffused and largely made up of all the members of the international society. You don't have specialized body in lawmaking in international law. It is the lawmaker is the business of the whole international societies. States in particular act mainly through policymakers, not jurists, either voluntarily by concluding treaties, voting for resolutions of international organizations, making declarations, or also the states make law more spontaneously by deciding to act in a certain way and gradually becoming aware that in doing so, they are complying with a legal norm in the case of customary rules. As will be explained in the next book of Professor Nemer Brant. Moreover, the absence of monopoly of lawyers in the handling of the law is not limited to making law. The same is true when it comes to implementing law. It is politicians who decide whether or not to apply the law, whether or not to follow the advice of lawyers, and whether or not to submit international disputes to methods of settlements which can involve, to a greater or lesser extent, legal considerations. This does not mean, of course, that lawyers are not involved in the process of developing and implementing legal rules. What is important, however, is to be aware that, with one exception, to which I will come back in a few minutes, with one exception, the role of lawyers or jurists is one of influence in international law, not usually one of decision. This exception, the exception, which occurs quite rarely in the international sphere, is when a dispute is submitted to a judicial or an arbitral body in order to reach a binding solution on the basis of law. Then, but only then, jurists, generally assisted by other jurists, pleaders, registry staff, decide, it being noted, however, that the actual implementations of their decisions, whether they are judgments made by judges, lawyers, jurist or arbitration awards, which are also in principle made by lawyers, depends, but the implementations of these legal decisions depends on the goodwill of the national or international political bodies. There is one nuance to what I have just said. It is possible, and this is happening more and more often, it is possible that domestic courts are called upon to apply international norms. In this case, but in this case only, the jurists regain control. But there are domestic judges, and I must say, unfortunately, domestic lawyers are quite often unfamiliar with international law. I don't know how it is in Brazil, but I must say that in France, I am not very confident that French judges really know some international law, and it can happen that their decisions are catastrophic seen from an international perspective. If they do not make law, fabricate law, I think that you should all try to mute your computers. If they do not make law, they do not adopt law, legal specialists play a significant role in the development of international law. Firstly, lawyers act as advisors of the actual authors of legal rules. And I am thinking above all of the legal advisors of foreign ministries or international organizations. As their name suggests, legal advisors or legal counsel, they give opinions on whether a legal rule exists or not, whether it should be amended or whether a new legal rule should be adopted, what is the exact content of the rule, what form should the rule take. The in-house counsel of private companies or NGOs, non-governmental organizations, play a similar role when faced with legal problems with international aspects. All these legal advisors have dual functions. They advise their employers or their client on what the law requires as objectively as possible, and on how to either apply it or enforce it. How to also, I'm ashamed to say that, but it is part of the reality of the work of legal counsel, how to circumvent the legal rule by limiting the risks of transgressions as much as possible, depending on the interest of the clients. Honestly, sometimes you also advise a client that, after all, its best interest is to violate the rule of law. When you act as a legal advisor, you can do so. The only thing you have to say, honestly, is be careful. If you do that, it might be your best interest, but you will be in breach of the law. Secondly, law specialists may participate directly as independent or governmental experts in the development and codifications of the rules of international law. As regards experts who are in principle independent, the best known example, not necessarily the most convincing, is the example of the ILC, where alongside retired professors or practitioners sit in a highly questionable manner, serving diplomats, legal advisors from foreign ministries, or even serving ministers. I must say, I have not the ILC where I sat for 21 years. I have not the ILC in very high esteem. It has become much more a mixture of government and governmental experts, which are now dominants, which are not independents, and honestly, many of them are not very good in international. I think that the ILC has lost his very high image it deserved in the 50s or the 60s, maybe in the beginning of the 70s, but now it is really very unequal. And my view is that you don't have a lot of very high international lawyers. Some are good, but unfortunately, it is invaded by diplomats of middle ranks and ministers. Well, a minister is not an independent expert. It is simply a shame to have them there. Same is true for legal advisors. Well, it was a parenthesis on my positions now concerning the ILC. And as another example of body of experts is the United Nations Commission on International Trade Law, the UNCITRAL, which is made up of government experts. And the same is true for the Hague Conference on Private International Law. And I think this is more dignifying. They don't pretend to be independent. They are representing their government, and they act as representative of their government, but usually they are good specialists. And I think it is a better system than to pretend you are independent while you are not. In the same spirit, it is not uncommon for international negotiations to be conducted directly by state agents who are legal specialists. This is particularly the case with regard to major international conferences aimed at adopting codification conventions such as the United Nations Conferences on Diplomatic Relations in 1961, on the law of treaties in 1968, 1969, on the law of the sea in 1958, 1960, 1973 to 1982, which gave birth to the UNCLOS, or in the Rome Conference, which adopted the Rome Statute of the International Criminal Court, or the Kampala Conference, which revised the Rome Statutes in 2010. In all these cases, and in many others, of course, the delegations were led mainly by the legal director of the foreign ministries of the participating states. And in addition, legal experts from NGOs can also play an important role during these kind of conferences. This was the case in the drafting of the Rome Statute of the ICC. It is also the case in all major conferences drafting conventions on environmental protection, for example, where legal experts from NGOs play a very important and I think very useful role. It is also the legal affairs offices that usually have the upper hand in bilateral negotiations on maritime delimitation, and this is in cooperation with the ministries of justice, on treaties relating to judicial cooperation or extradition. In all these cases, however, the delegations, even when they are made of jurists, receive detailed instructions from their government. As for when jurists are not on the front line, so outside these conferences, which are led by government experts, lawyers are nonetheless frequently called upon to participate in international negotiations as members of more political or technical delegation, in which their expertise is often indispensable, if only to draft the final clauses of the treaty, those that determine, in particular, the conditions of its entry into force and revisions, or to ensure the conformity of a resolution with the conformity of a resolution with the constitutive act of the organization which is adopting the resolution. I must say, I started my career as a practitioner as being the junior legal advisor in many international economic conferences, the UNCTAD or the GATT, where I was sent by the minister because I really begged the legal advisor, please, I want to practice. And he told me, well, if you want to practice, we have no money, but if you want to participate in the conferences, you can be the legal advisor of our delegations. And I must say, I learned a lot just following, but they were very imprudent because they left me negotiate, and I was very young and a very tough negotiator, which sometimes put France in some difficulty. Moreover, it is often the case that certain intergovernmental bodies dedicated to the study of legal issues are composed of persons trained in international law, or supposedly so. This is the case of the Sixth Committee of the UN General Assembly, which is increasingly haunted by diplomats with little or no legal training, which is really a scandal. I think it is an unfortunate situation. And for whose work, the Sixth Committee, I must say that I confess that I have little regard for its work. Repetitive speeches, lack of genuine negotiation, nobody listens to the others, just read speeches without any spirit of compromise. At least that is my experience in reviewing the work of the ILC. They speak, they make speech at home, they don't listen, they don't try to find better solutions, more politically acceptable than what the ILC has prepared. For their part also, most of the UN specialized agencies have established a committee to deal with legal issues, and particularly prominent is the role of jurists at the ILO and the very powerful legal affairs services of the European Commission and European Council. I suppose that in the Mercosur as well, they have a team of lawyers. Last but not least, there are jurists who populate the law universities, the law faculties, and often, in the case of international law, the political sciences faculties, the professors and researchers which are specialized in public or private international law. These persons study the rules of law. They attempt to systematize them. As I explained when starting, I try to find a theory of reality. In my course in The Hague, I have not found this unreachable theory. And in so doing, professors or researchers play an auxiliary but not insignificant role in international law, even if this role is not always fully recognized. In what Article 38, paragraph 1d of the statute of the ICJ called the determination of the rules of law. And after all, it is the professors who train the decision makers of tomorrow. So in this respect, they have a real role to play in the future making of international law. The same observations can be made with regard to the role of jurists in the implementations of the rules of law. Leaving aside the role of judges and arbitrators, jurists are present, very present, in the application of the rule of law, but they help to apply the law without, again, being the main actors. This implementation is more generally the work of state bodies or individuals who do not have necessarily legal training. This involves, here again, legal advisors who can advise political bodies or arbitral decisions. And this advisory role can, of course, be exercised by non-official advisors from universities or law firms. And quite often legal officers of the ministries of foreign affairs call on professors of international law to advise them. I don't know if Professor Brant plays this role with the Ministry of Foreign Affairs of Brazil. I think the minister would be well advised to ask him. But so they have the ministers of foreign affairs have the benefit of inside legal advice from the legal advisors of the minister, but also of outside legal advisors. In this respect, you probably tend to think first of lawyers who act as counsel or advocates before international courts or tribunals or other dispute settlement bodies. But you should keep in mind that while oral or written pleadings are certainly useful, I don't want to saw off the branch on which I am sitting, but it must be borne in mind that before being advocates, practicing internationalists or international lawyers are consultants. When parties to a dispute, whether states, international organizations, or private individuals, want to assess the strengths of the right they are claiming, of the possible strategies for asserting their rights, for the relevance of a particular methods of settlements, they often turn to international law generalists or specialists in special fields, depending on the case. This role of counsel, the word as a general connotation, this role of counsel is itself very diverse, as Laura Wassel, who is an American lawyer, remarks, and I quote her, "In seeking a lawyer, you are looking for an advocate, an expert advisor on the law and on your rights and responsibilities, a strategist, a negotiator, and a litigator." And one might add sometimes even a psychologist and a confidant. When you advise a state, you must, first know everything about the case, and you must try to say, well, this is not a very good case, but we will do the best we can. And once maybe the best is not to win, but to empty the case, to end with the dispute. Thus, to conclude on this whole, making law refers to multiple, maybe doing law would be better, refers to multiple activities: studying the law, systematizing law, fabricating international law, implementing international law, even violating international law. All of these constitutes what is commonly called the practice of law. Just a word on this problem of breaching or violating law. My view is that when a rule cannot be breached, it is not a rule of law. You cannot, if you order your population, if you decide in a treaty that your population should stop to breathe 1 day over 2, it cannot be law. It is impossible. But if you put in a treaty that the populations of both states will be compelled to breathe at least once every 10 minutes, it is not law either. It is natural obligation. So law is something which can be violated otherwise, and which can be respected or violated. Otherwise, it is simply not real law. Well, I would now like to take some time to evoke a particular aspect of the way of doing law, of making law, which consists in thinking international law, thinking international law being understood that thinking does not prevent one from acting, and that according to an often quoted expression of Henri Bergson was a French philosopher of the middle of the last century, one must act as a man of thought and think as a man of action. One must act as a man of thought and think as a man of action. And I think that this is very important. At least it has been what I have tried to do in my long career. How long? Well, I have said 10 more minutes, or should I stop here, Leo?
Yes, you can continue, Professor.
Okay.
Yes, you have 10 more minutes or even more if you want to.
Well, yes, but if we must stop, I always enjoy discussion with public, or with you.
Okay, so 10 more minutes, you'll be okay.
Okay, so let me try. Okay. If law is a tool serving a purpose, there is no reason to make it there is no reason not to make it an object of reflection as well. In a very interesting book published a few years ago entitled International Theories, an inquiry into different ways of thinking international law, Andrea Bianchi, who is a professor in Florence, I think, insists in the introduction on the theories of international law, and I quote him: "The simplistic representation that practitioners get the job done on the ground while the theorists are caught up in useless debates is misleading and ill-conceived. Practitioners, even when they are not conscious of it, presupposes and act on the basis of a theory or method, a set of presuppositions and beliefs that constitute the necessary background for the exercise of their professional skills. And a little further, he writes, inevitably, somebody who possesses the analytical capacity of discerning what he or she is doing on the basis of underlying theoretical premises or methodology will have a comparative advantage over those who do not question and simply regard themselves as engaged in some technical craft. End of quote. Indeed, one can understand the fascination of the theory of law, and especially international law can have for academics. All law is a child of politics. As has been written, law is a successful policy. And it is something which is deeply in my mind. Law is a successful policy, a policy which has succeeded in being translated into law. But international law is more particularly close to politics in that the relations between the two is unmediated and in some way sanitized by recourse to highly institutionalized processes, legitimized by a long history of acceptance by the social body and individuals within it. Domestic law is, I would say, is internalized. I have lost my domestic law is internalized as not only law, but as the law par excellence. And it is because international law does not resemble domestic law, is not alike internal or domestic law, that its legal nature is often challenged. But it is also why international law is a particularly promising laboratory for reflecting on the very nature of the legal phenomenon in general. Whether in international or in other branches of law, legal theory by itself cannot dictate action, but it can inform the choices of the stakeholders between various alternatives. And I think that you should not underestimate the value of reflecting on the law and attempting to systematize it. But it is regrettable that this systematization, sorry for my English, that these systematizations sometimes falls into a void. And when reading the writings of legal theorists, we think that they might also be better off making law rather than confining themselves to a purely intellectual critique. As Louis Henkin, one of the greatest American internationalists of the second half of the 20th century, said in an interview by another great Italian internationalist, my late friend Antonio Cassese, Henkin said, even if law is process, we who work in the real world, Henkin worked for a very long time in the UN, we who work in the real world have to be able to stop the process at a particular time and ask, where are we? One of the roles of, this is my addition, one of the roles of the doctrine is to engage in this reflection. It is not always easy to do that, but it is important. It has, I think that the doctrine played a more important role in international law than it does in domestic law. as a subsidiary means for the determination of rules of law, as said in famous Article 38, paragraph 1d of the ICJ statute. The doctrine exerts an influence in the creation and the application of international legal rules, with a view to establishing the existence of those rules, their content and their scope. More generally, the writings of theoreticians has a twofold function. On the one hand, their function is to give an account of existing law by describing, possibly commenting on law, and even criticizing existing rules and the way in which they are implemented. On the other, to systematize the existing rules and to try to present them in a consistent manner. This is because international law is a jumble. It is a bric-à-brac, as was written in French. If we limit ourselves to describing the pieces of the puzzle. But it can become a system when it is described by able interpreters who manage to give at least an appearance of coherence to this puzzle. I am not at all hostile to this exercise of systematization, and I admire those who try it. However, and this is an important warning in my view, however, the theory must be in touch with reality, must not lose sight of the primary function of the law, which is to facilitate relations between the addressees of its rules, but providing the means to enforce rules. With this in mind, it seems quite clear to me that not all theories are equal. Their coherence is less important than their realism. Their intellectual appeal is less important than their usefulness in enabling legal rules to provide the services expected from them. I think that you must be careful that not to be just theory builders. In fact, from my point of view, there are two very different conceptions of systematizations. And I have a little taste for the first one, which considers law as a game of the mind, detached from reality. However, there is no more pure law than there is pure theory. And I fully agree with Louis Henkin, another American very important author of the last century, who said that he had problems with the positivists, particularly because they tend to treat the law as hermetically sealed off from anything else, from both international politics and from national law and politics. I can also subscribe to Henkin's opinion that, and I quote him, law is part of international relations. Inevitably, we have to establish the nature of international order. Then we will see what our international law is, and then put some theory under it. Unlike the Kelsense of the world, I start with life and put law and theory under it, rather than the other way around. Kelsen had a very impressive mind and a great spirit, but bad. And I think these three suspension points speak volumes. Starting from reality to act on reality is, in my view, the role of legal theory. And I dislike, I must say, the so-called new critical studies, which just criticize without offering any positive view for reconstructing and helping in the application of law, or even for improving the law. I have noticed either for the so-called New Haven School, which use law much more as a tool for politics and for promoving political ideas. I think lawyers can help in promoting better law, but they must never lose sight from reality. Honestly, from my point of view, only two general schools of law are helpful. First, the positivists. I don't share their view. I think positivists are voluntarists, so the thing who think that law is built or is only made on rules accepted by states. This is not true. I think that some rules are above the will of states. You cannot commit genocide, whether you want it or not, even if it were part of a treaty. So I don't like positivism, but at least it tries to be in contact with reality. The other doctrine from which I am part in a way is the objectivist school, and more especially the sociologic school of objectivism, which think that legal norm is a result of relations of equilibrium and relations of power. I see that my good friend Francesco Rezak is here. Hello, Francesco. I think that Judge Rezak is positivist. I am not, in that I trust in real law, the one which is applicable, but all the rules do not stem from the will of the state. They stem from power relations, and they must take some form, but it is the will of the state is not always free, and it is not true that all rules come from this. So this is I wanted to finish on that. I trust in law as a tool. I think that lawyers must be honest, must not take their will or their wish for the reality, and especially professors must offer law not as they want it to be, but as it is, and it is a result of rather complex processes. In that respect, I am not a voluntarist positivist, but I am a positivist. What is important is the law as it stems from reality. Maybe now I should stop, because we have at least half an hour, but I'm open to have nearly 1 hour of questions and answers if what I said can be a bit interesting for the public.
Thank you very much, Professor Pellet. Eu gostaria de anunciar a presença do ministro Rezak conosco. O professor Pellet já fez menção a ela. Muito obrigado, ministro Rezak, por partilhar conosco sua presença. Nós também teremos o prazer de ter a sua conferência em breve. Muito obrigado por estar aqui conosco. But, Professor Pellet, you have some questions from students that they will ask you directly as you order, as you wanted. But before that, I would like to make some questions. Is that possible?
I am in your hands.
So that's it. So you said that law is not an end in itself. Law is a tool. You wrote that in your book. Law is an instrument in order to create peace and coexistence. I think that this phrase is not too much optimist in itself, because I think that one of the most important functions of the law is to preserve or even to legitimate power in itself. So the end of the law is not only peace or coexistence. States are looking for sometimes chaos and war, and even power, and using law as a tool and as an instrument. So I'm asking you if you agree with that assumption. So the second question is that.
Oh, maybe I answer.
Okay, that's better. Okay.
Because it's a large question. Well, you have not sent me your last book, so I don't know what you have written in the first volume. But in this respect, you are not one of my successors. I think you are more what I call a use naturalist. That is, you have a certain ready-made idea for what the law should be, and then you think that lawyers must preserve this ideal idea of law. This is not my view. My view is that law, again, is a result of a sociological process. It is a politics which has succeeded. And the first work of a lawyer is to know what the law is, not what it should be. Then, since he knows it, he or she knows it, then it is the work of the lawyer to criticize the law, to say, well, look, this is the result of conjunction of powers. I think that it is a disaster, and I strongly think that it is possible to improve it. But I don't think it is good law to say law is what it should be. Law must be moral. It is not always moral, and moral is something personal. Each lawyer has moral ideas, but moral ideas and legal rules are, from my point of view, something different. And you said that I was not very optimistic. It is true. In the world as it stands, with China, with Mr. Xi Jinping, I am very politically incorrect, and I don't hesitate to criticize. With Putin in Russia, with Bolsonaro in Brazil, I think people who don't really care about law, I think it is important to say, well, for the moment, law is bad. And for the moment, you are bridging it. Trump was in breach of international law nearly every day. And I was among those who very strongly warned about it. But when you have all these three giants I have just mentioned, China, Russia, and Brazil, and there are unfortunately many others, even India, who was really a law-abiding state, has become now rather doubtful supporter of law. But if they succeed in changing the law, I think we as lawyers, we can say, this is bad. We don't agree that the direction for ethical or moral reasons. But unfortunately, this is a law. Fortunately, when you are not a voluntarist, you can also say, but for the moment, there are rules which are above the will of the states. For example, but there are very few. The prohibition of the use of force, contrary to the Charter of the United Nations, the prohibition of genocide, and some very important international crimes, but that's all. For the moment, these are above the will of states. But if, I hope it will not happen, but if all these states I have named finally agree to change the rule of law and to promote new rules of law, I'm afraid that the role of lawyers will be to say, regrettable as it is, the law has changed.
Okay.
Sorry for
No,
disagreeing with your very moralistic and probably more pleasant view than mine.
I think that my problem is the word. I mean, the finality of law is to create peace and coexistence. And I think that we need to include power, or to legitimate power, or to preserve power as a complex process in order to create law. That's my point, because I think that even states are always thinking about how to preserve power in order to create law. That's the only thing that I would like to put it on. But anyway, my second question is that well, you said that law only exists if it can be violated. That's a very interesting point of view. But at the same time, you said you cannot commit genocide, for example. So how can you see this expression?
Of course you can. Of course you can. There are genocide. There are genocide, and they are in breach of a rule of jus cogens.
Of course. This is not my point. My point is that when you describe law as law, only can exist if it can be violated. It's not there is not a contradiction in your view.
I don't see it as a contradiction. The problem is that if you have many violations of law, not only jus cogens is more difficult to be violated than other rules, but if you have many violations, then the law will change. This is a famous, the famous image concerning customary rules. How many grains de sable, would you say that in English? Grains de sable.
Oh.
Combien de grains de sable font un tas de sable? How many sand?
How many sands can?
Grain of sands.
I don't know. How can you?
How many passes in the meadows make a road. It's a problem. The first time you violate law, it's a violation. The second time, it's violations. The 100th time, the law has changed because states don't feel they are bound by the law. For me, it's a criterion, but it is another part of my general view of law. But for me, the criterion for law is opinio juris, the feeling that a rule exists. The feeling can change, of course, even for jus cogens rules. When the feeling has changed, the rules exist no more and has changed as well.
Okay. Thank you very much, Professor. Thank you very much. Fernanda,
there are students here that would like to ask Professor Nemer.
Okay. Can you lead
Deborah? Sure, of course. Deborah,
Yes.
do you want to ask him?
Yes, I'd like to ask a question. First of all, I would like to thank Professor Pellet for the wonderful contribution. In behalf of myself and of my classmates, we've all been talking about how much we've been enjoying your class, so thank you very much for that.
Thank you.
And I would also like to ask more of a practical question. For us young lawyers who are just beginning to tread on the waters of international law, if you'd have one piece of advice for us on how to position oneself in a position of a practitioner of international law as young lawyers who are just starting out on this field, what advice would that be?
It is, in a way, a classical question. First, I trust in opportunities. Just to speak of myself in this respect, I wanted to be an ambassador. Fortunately, I was not. I am so unpolite and rude that I would have been a terrible ambassador, I think. And then, for special reason, it happened that I was 21 in 1968. And I don't know if you know about 1968 in France, but it was a revolution, students' revolution. For a month, France were totally paralyzed by us, by the students. And I thought, no, I don't want to be, to serve the state, so I will just try to be a professor. And it happens that I was I succeeded in what we call the aggregation, and I was appointed a professor very young. I was 27. And then I had some opportunities. First opportunities, my master, one of my masters, who was Nguyen Quoc Dinh, a French, Vietnamo-French professor, died just after having written a masterpiece, treatise in international. They wanted, his family wanted a successor, and they asked me. Then I was asked very young to be a member of the ILC, and I must say for political reasons, because I was left-wing, and the president of the Republic was looking for French professors, and all the French professors are very conservative. So I was the only one who was moderately left-wing, so they appointed me in the ILC. But before this, in 1983, I was asked by Nicaragua to be one of the counsel against the United States of America in a case, I suppose all of you know the famous case, Nicaragua versus the USA, and I was one of the three main advocates. Although I was young, but I could tell you the story later, maybe. I was asked to be, and then it worked well. People come to the ICJ to listen to pleaders, and they make their market. They buy advocates there, and I was retained then by states. I had the pleasure and honor to plead in front of Judge Francesco Rezek, for example, but many others. So the first thing is try to look at opportunities. Opportunities come, but of course you must be. You must first get your degrees in good conditions. I think degrees are not all, but I am among those who trust in degrees. You must have degrees from good university, in good universities, in good conditions. And don't forget, the places are rare in public international. You have much more in private international, but in public international, and especially in states like Brazil. Brazil has, I don't speak of your particular government by now. I think it is, fortunately, it will not last forever. But I speak of Brazil as a state which has a very strong policy of not accepting compulsory jurisdiction, binding modes of settlement. So it limits even more the possibility for Brazilian lawyers to participate in international litigation. But well, I go back nevertheless to your question. First, be good. And I think, and if you are not at the top, don't hope that you can really, the competition for public international is too hard to expect that if you are just average, you can succeed. Second, don't neglect domestic law, because the best opportunity to practice international law for young lawyer is to practice it before domestic courts. And again, especially so in Brazil, since Brazil obstinately refuses international law proceedings, binding proceedings at least. So while before Brazil's national courts, there are opportunities. You have to apply the human rights covenants. You have to apply the Mercosur treaties, etc. So this is really something particular. I also, for public international proper, it is clear that it used to be a bit confiscated. Hi, Francisco. It is a bit confiscated by, it used to be a bit confiscated by professors. Now it's no more true. It is unfortunately confiscated by law firms. And many advocates in law firms knows international law a bit like I know physics or mathematics. They are not good in international at all, but they think they are good. And I see that in the ICJ, maybe Judge Razak could confirm or infirm what I say, but in the past, before the ICJ, you are only quite high-ranking international professors. Now you have a lot of advocates from usually Anglo-Saxons law firms. Some are good, but some are not good. But they are from international law firms. But this is to say that after all, maybe the best chance to practice international is to join a law firm, a big law firm. The biggest are American or British, but some are French, some are Swiss, some are Belgian. And I don't know if you have big law firms in Brazil. You certainly have American law firms practicing in Brazil. But I think this is the best chance to practice some international, in particular investment law. And my view is that investment law is very accessible for public international lawyers. I am a nullity in commercial law. I always refuse to consult in international commercial law. For me, it's very different from my law, which is public law in principle, while investment law is easy for an international lawyer. You can easily, and then you can practice it through law firms.
Perfect. Thank you. If it would be okay, I would like to ask a question on behalf of a classmate. She asked me to ask you about the virtual age we're inserted in and how much it shapes and influences our society and what part it plays in international law and how it shapes it.
I am afraid I lost the very first part of your question.
The digital age. It's about the digital age and how much it influences and forms society and what kind of part it plays.
I still did not understand your first word.
Technology,
digital
maybe?
Technology age,
technology.
Virtual digital
Okay.
technology age. Sorry, my pronunciation might be off.
No, it's my Franco English. So how do new technology influence international law? That's the question.
How it influences the way international law is shaped.
I don't think it changes it a lot. It changes in that the information is much more accessible. You can easily be lost in Google or even specialized websites in law or even international law. You have so many information that you become to get lost. It is both the best and the worst thing. You have too many, but at least you have. While in the past, even when I started my job as counsel before the ICJ, for example, you really had to go to a library to look at the old books and to find what you were looking for. While now I just sit at home in my personal office where I am when I am speaking to you, and I don't need I have books just to show that I am a professor, but I don't use books. I am like you. I just go. So this for me is probably the real answer to your question. But there is something which is more important than how it is to try to legally canalize all these new technologies. And this is really, for me, the question for the future. These technologies are rather terrible in some respects concerning human rights. And for the moment, these technologies are not well framed by the law. Among my practice, I had for some years, 2 or 3 years, I was appointed by the ICANN. I don't know if you know what is the ICANN. The ICANN is I don't even remember what is the meaning, but it is a Californian NGO association which rules the access name to the internet. For example, if your access is pompeo@gmail.br or .com, it is ICANN, which you have to go through ICANN. And the ICANN asked me to be the independent controller of the names. So the offered is not really the word, because it cost nearly $300,000, $300,000, yes, to get a new name after the last dot in the name. And I was asked to decide whether the names were in conformity with public order and with international morality. And it was extremely interesting. I had to, for example, I opposed .amazon because I thought that .amazon could not be confiscated by a private firm, which is Amazon, because I said, no, Amazon is the common name of all the countries around the Amazon. But I could only oppose, but if it was contested, I had to go to arbitration. So it was independent controller against Amazon, and I lost. So on this one, I also fight against .health. I didn't want that .health be confiscated by a private hospital in the US. I lost again. But I also refused to oppose some name like .sex or .gay. So this is not contrary to public order. Just if you don't want to go to sex, or you just don't click, and that's it. So I don't see why. And I was very much criticized by the public in doing that. So, but this is to say, and so I know rather well these issues, especially on names, and it is often said, well, it is not normal that it is controlled by these private Californian NGOs. And my view is that it is better than if it were controlled by states. If you leave it to an interstate organization, then you would have all these states which I have named during the before. You will have all these illiberal or dictatorships who would say, oh, but you have to control all and everything. I prefer free internet with some kind of control. But nevertheless, you need more rules than that. Well, next.
Okay. Thank you, Deborah, for your participation. Thank you, Professor. I'll just read a question that arrived on the chat here before passing it on to the other students that are here. Murilo asked, how did you see the growth of conservatism among the countries, and if there is a specific role that international law could play in the relationships of states? What is your opinion?
This joins Leonardo's question. Whether you like it or not, that is life. Personally, as you might have guessed, I am not conservative. But as a lawyer, I just follow. I try to help in giving advices to try to avoid these new trend in international law. But if it has to become conservative, I'm afraid that lawyers must accept it. For the moment, you have some how do you say that in English? You have some limits, some caveats. Nearly all states are parts to the 1966 covenants on human rights, at least to one of them. And I think that on this you can say to China, well, you have ratified the covenant, the first covenant, that on social and economic rights, you must comply with them. For the moment, I think we still can consider, for the moment, I think we can still consider that the prohibition of torture is a rule of jus cogens. For the moment, but I must say that with these so many states breaching it, maybe it will not be the case forever. For the moment, I would recall these two states who practice torture, because they still say, no, we are not practicing it. Oh, no, it's very limited. So as long as they defend themselves, you can say that it is jus cogens, that it is a peremptory norm. Will it be possible forever? I am not sure, and I would be very sad that it has changed. But as a professor, I think that honestly, I will have to say, it's a pity, it's a scandal, it's a mistake. This is because of these horrible tyrants and dictators and illiberal prime ministers or president. But as a lawyer, I must admit that it is no more true.
Professor, it's very intriguing, your answer. So do you really think that a costume like that doesn't apply to what we have right now, it can really cause a regression? So it is possible to have a backtracking, a regression on these use cogents norms that we have?
Just read the 1969 Convention on the Law of Treaties. It says that a new rule of jus cogens rule can happen, and it does happen. And I don't know why what is possible one way would be impossible the other way. Again, it is very sad. It is rather difficult to envisage because, as was said by late Ian Brownlee in a very famous formula, jus cogens is a vehicle which rarely goes out from the garage. And why? Because states have a kind of very strong social pressure on them. But again, which is true for genocide, probably true for aggression, probably for other use of force contrary to the Charter of the United Nations, is not certain for other rules which we consider as jus cogens for the moment, like the prohibition of torture. I take it because is it a jus cogens rule or not? I am not entirely sure. But I would rather teach that it is for the reason I told you. But when China will have stopped, or Russia will have stopped to defend itself when it practices torture, and say, oh, come on, we can torture our Uyghurs and our nationals as much as we can. If the other states are not unanimous in condemning China, I'm afraid that as a lawyer, I must have to be, in all honesty, to say, it is not my international law. I don't recognize it as legitimate, but legitimacy and legality are different.
Okay, thank you. I'll pass it on to Mateus, who has raised his hand. If Professor Rezek wanna speak or say anything, we are open, Professor.
No, you are mute, Francisco. You are mute. No, you are still mute. Still.
Maybe your volume is down, Professor.
Está mudo, Rezek.
He unmuted, but we're not listening to him.
No?
Okay, we'll make another
pity.
try.
I would have liked to fight with you on voluntarism.
Okay, Mateus?
Hello, is everyone listening to me?
Yes.
First of all, Professor Pellet, it's extremely honored to be here. Sorry about the dogs, that's my neighbor. But I really like to touch again on the second question of Professor Leonardo. I felt extremely intriguing your lecture about how the law can be violated as well as being respected.
It's very difficult to hear you, not because of the dogs, but because of the volume which goes.
I'm sorry. Just a second.
It looks better already.
Speak closer to the microphone, Mateus. Try again.
Yes, I'm so sorry. That's probably my mic. Is everything all right now?
Yeah, if you speak slowly and near your microphone, I will probably follow.
Oh, okay, I'm so sorry, Professor. I was trying to say that I felt extremely intriguing your lecture about how the law can be violated as well as can be respected. And I fully understand and agree that the law is something mutable. Like you, sir, just said, even jus cogens can be sometimes can be mutated. Yes, can have a backtracking, can have an evolution. And I felt, just reflecting about this state of yours, can it be an extremely dangerous situation? I mean, from what I understood, the work of a lawyer on the international environment demands advertising, negotiation, counseling. I mean, is this a dangerous situation? Because the international environment has not many people who has a training on the legal terms, on the legal intelligence. Can this possibility of the law being breached generate a perilous situation on the international environment, in your opinion, Professor?
I'm not sure you don't mix two quite different questions. First of all, my view is that definitely law is something too serious to be put into the hands of lawyers. I think it is very important that law is made by politicians, and of course it would be much better if all politicians were democratically elected or things like that. But again, I think that technique is not politics. I think it is important that the politicians have their word. I don't like many politicians, very honestly, in the world as it stands. I have not a lot of politicians I love, including my president, but although I think he's one of the least worst, but he's not one of, but I wouldn't say that he's perfect, far from it. But I think that politicians, lawyers should be a bit less, a bit more modest. I think that students in law are not modest enough. They don't accept that law is not everything. Law is not everything. Morality is more important. Politics, I think, is more important. I don't think that you must just think, oh, the poor lawyers, they don't. No, I don't think it is. It is the good answer. So this is. I think it is, in fact, my main answer to your question. And we still go, will there be regression or not? I must say that if we had spoken 1 year ago, during the Trump era, I would have told you, I am rather desperate. This clown will be re-elected and is more important than the Mr. Orban in Hungary, or even Mr. Bolsonaro in Brazil. So if Trump had been re-elected, I would have think that 8 years of Trump could have changed totally international. As I am not a fan of Mr. Biden, but I think he does well. He tries to reconcile the USA with international law, with multilateral law. And I think that there is a chance that at least the bad trend of international law will be a bit slowed down.
Okay. Thank
you, Professor.
We have warmed up, and now there are a lot of questions, but we only have 10 minutes, Professor.
Okay.
Carla, you want to make him a question? Go ahead.
Yes. Je voulais d'abord parler en français parce que ça me fait plus plaisir de parler en français qu'en anglais. Donc, bonjour, Monsieur Pellet, ça me fait trop plaisir tout d'abord je vous remercie d'être ici, d'avoir l'opportunité. Et puis, donc, ma question, elle est simple. Donc, ça fait 2 ou 3 semaines qu'on a un examen du CEDI qui est versé sur la responsabilité de l'État. D'accord? Et donc, on a eu beaucoup de discussions entre nous Et une des questions, c'était que ceux qui ne sont pas soumis au droit international, ils pourraient être internationalement tenus responsables d'un acte que c'était une liste. Je m'excuse, hein,
non,
je suis nerveuse.
Je vous écoute, j'ai pas de problème. Je voulais juste savoir quel était votre prénom. C'est Perla ou c'est Sylvain, votre prénom?
C'est Perla.
Perla, ok. Donc, la question, the question is, if I understood it well, whether non-subject of international law could be internationally responsible. Is that the question?
Oui, tout à fait.
Okay.
C'est ça.
Then, so I answer in English for everybody being able to follow. Usually people can follow my English. In the UN, it was said, he doesn't speak English, he doesn't speak American English, he speaks Pellet's English, but they understand. So the answer is first, I have a very open view of what is a subject of international law. I think it would be more true to speak of an addressee of international law, those who are the addressee of the rules. And these addressees are always responsible under international law or not. Well, because of international law. It can be before domestic court, but they will be nevertheless responsible because they have violated a rule of international law, say a treaty rule which is addressed to nationals of the state. I try to be a bit short because I am threatened to have to stop in 5 minutes. So maybe the other question.
Merci.
Yes, thank you, Perla. Merci. I think Professor Pellet has fixed his microphone and he wants to dialogue with us as well. I don't know.
Whom, Professor Rezek?
Oui, I think so. If
No,
he's not...
We still cannot hear you, Francesco. That's a pity. Where is the microphone?
Yeah, his microphone is on, but we do not hear him.
Did he try using some earphones? Because sometimes the computer microphone doesn't work.
Francesco, tu as il y a une petite truc rouge en bas à gauche de ton écran. Si tu cliques dessus, peut-être tu entendras. Sinon,
on peut passer à une dernière question. Taina, you want to be the last one, and then Professor Nemer can make his final statements for us. Taina, you want to?
Yes,
okay,
teacher. Yes. Good morning. Thank you, Professor. I have one question. How do you see the future of the international law? Do you think something must be developed, approached? What do you think about the future of the international law?
As I told you, law is the son or the daughter of politics. So I am not Devin. I am not a sorcerer. I cannot read in a crystal ball. I think the answer to your question is how international relations will evolve. If it evolves in the good sense, and for me the good direction is coming back to decent multilateralism, to accepting that human rights are not different for the Uyghurs or for the Corsicans or for the Brazilian Indians. So human rights, basic human rights are universal, things like that. If great powers succeed in coming back to these basic, it's okay, and there will be no recession, and progress can be made progressively. But if the dictatorship is maintained forever in the second and maybe in the future the first world power in China, if Mr. Trump has a successor or succeeds himself within 4 years, if big countries like Brazil keep on ignoring what real democracy is, I'm afraid that I am pessimistic. As I told you, I don't hesitate to tease you on Brazil as well, because it's a country I really love. It's my second country, so I am so sorry of seeing how it evolves by now. So as long if these trends go on, I am pessimistic. But again, it doesn't mean that international law will not exist anymore. The more sovereignty is affirmed, the more you need international law for, Leo, but for coexistence. Sovereign states can only coexist if there are some rules. And even the most powerful need that. Otherwise, it is the end of statehood. Statehood supposes coexistence, and coexistence imposes international law. But it will be, unfortunately, a different international law with more sovereignty and less cooperation. So,
Okay.
Thank you, Professor. Thank you
Can you
so
hear me
much.
now, Professor?
Oh, yes. Yes.
It's my dear friends, this is just a word to say how much I'm happy, pleased to see and to hear again Professor Alain Pellet, one of the most outstanding masters and permanent inspirations for all members of the International Court of Justice. It's a pleasure to see you and to hear from you, my friend. Congratulations again.
Thank you, and thank you for being here, friend.
Thank you, Professor Rezek, for your words. Thank you, Professor Pellet. I'll pass it on to Professor Nemer so he can greet everybody, and thank you. Thank you very much.
Thank you.
Thank you, Professor. Thank you, Minister Rezek. Thank you, Professor Pellet. I absolutely agree with you. It was just one small provocation, my first question. And I really hope that we can have you here in Brazil next year, maybe in summer, or in March or even April. Will be better for you. I know that, and I will work on. So,
March is okay, not July.
March will be better. Okay, so we will work on it. So thank you very much for accept your invitation. Thank you very much for your speech. And we will continue our winter course with the project and with our next class. So thank you, Professor Pellet. I hope to see you soon. And thank you very much. And bye-bye.
Bye-bye, and sorry for being a bit provocative.
Thank you very much. Bye-bye for all.
Bye.
Thank you.
Enjoy the course.